some quick thoughts about why did this happen? Why did Northern Republicans, why did Northerners let this happen? I mean, ultimately, the only bulwark against this process is going to be the Northern Republican Party. And its support is beginning to ebb. Just some quick things. We looked at this summer. This is an amazing document. We're going to look at it closely after lunch. This is a Democratic campaign thing from 1866, attacking the Freedmen's Bureau and the Republican gubernatorial candidate who supported it. And here you see hard-working white people who have to keep working so his children can eat, plowing and chopping wood. Well, this black person with the kind of exaggerated lips and big white eyes, like a minstrel stereotype, living off the fat of the land, wanting something for nothing. I mean, if you ever wanted to see an example of this country's capacity for turning racial reality inside out, the uncompensated labor of black people had supported whites for 246 years. 6 months later, the political story being told in this particular document, a story, here I will editorialize, that we still often tell is of hard-working whites having their own prospects dimmed by lazy black people living off the federal dole. The last gasp of the older spirit of Reconstruction was the 1875 Civil Rights Act, passed as a tribute to the recently died Charles Sumner, which barred discrimination in access to public accommodations. But the federal government even then was unwilling to supply any enforcement mechanism, and the law was in any case overthrown in the Supreme Court in a case in 1883. The court would play a very important role here. This is the last point I want to touch on. In this period, as in other periods in our history, the Supreme Court was a bastion of conservatism. And it would read the Reconstruction amendments in an extraordinarily narrow way. Larry, this in some ways gets back to the question you asked. I won't go into the details, but in the 1869 Slaughterhouse case, for example, a Louisiana case, and the specific things have to do with a monopoly on the city slaughterhouse in New Orleans. The Supreme Court actually draws a distinction between federal and state citizenship. And it says the federal government can only protect you in the exercise of your federal rights, those areas that are explicitly described in the Constitution as the purview of the federal government. So you, for example, have a right to navigate interstate waterways, because that's a federal prerogative. And nobody can take that right away from you. But you don't have the right to sit in a theater. In the Crookshank case in 1876, another Louisiana case, this reflected growing out of an attack on a meeting of black people by Louisiana whites and another massacre. The court ruled that the federal government had nothing they could do about this because the 14th Amendment, guaranteeing equal protection of the laws, only ensured that states couldn't discriminate against you, but that had nothing to do with private action. So since these people were private actors, like a theater owner might be a private actor, like a mob trying to kill you is a private actor, there's nothing that the federal government could do. So you see the 14th Amendment being narrowed. This process would culminate, as we all know, in the Plessy case, which said the guarantee of equal protection of the laws does not prevent segregation, so long as people can be given separate facilities, so long as they are separate but equal. The same thing would happen. That, by the way, is Homer Plessy. 7 white great-grandparents, 1 African-American great-grandparent. Men chosen. They had to tell they wanted a test case. They had to tell the conductor which the black guy was. The court would do the same thing with the 15th Amendment. The 15th Amendment said you could not deprive people of the right to vote based on race, color, or prior condition of servitude. It didn't say you couldn't deprive them of the right to vote for other things. Poll taxes, grandfather clauses which would exempt people from paying their poll tax if their grandfather had been eligible to vote. Literacy tests. A whole battery of new initiatives would come that would effectively disfranchise black people without, according to the Supreme Court in its Reese v. U.S. case in 1876, without violating the 15th Amendment, because the right to vote was not being restricted based explicitly on race, color, or prior conditions. Thus did the Supreme Court consolidate a process of violent overthrow of Reconstruction in southern states, a process of growing northern racial indifference, and a process of legal narrowing of the 14th and 15th Amendment down to a virtual nullity. It would be, just as a final thought, the state of Mississippi that would pioneer that process with a constitution enacted in 1890, which developed a series of mechanisms for effectively disfranchising black people. We will talk about the Mississippi State Constitution, which, if I'm not mistaken, is still the state constitution in force today when we get together again. That's what I got. Thank you. I'd like to take, I know you probably just totally rung out, but take a few minutes. It's a lot to get through. Hearing thoughts, comments, we got maybe 8-9 minutes. Just to hear thoughts, comments, then we'll go to lunch. We can continue to talk about this at lunch. We'll revisit it with a primary source exercise after lunch. But comments, questions, thoughts, what's not clear, what interests you, what struck you, what surprised you? Kind of depressing, that's the first one. Kristen.
The Civil War issue, no matter what the North or the South, they still had two different ideas as to why the Civil War actually started. So in the end, the South was still fighting for what they call the states' right.
Yeah, in other words, so one of the things that's interesting, and we talked a little bit about this last year, I think that the South seceded over the slavery issue. And it just couldn't be clearer. They couldn't say it more clearly than they did in ordinances of secession. But part of what you're getting at, and it speaks to this question about why don't you see that Colfax riot marker? Right? There's the history of what happened. And that, let us be honest, right? None of us ever knows that. We don't have time machines, right? There's the history of what actually happened and the infinity of individual motives that's behind it. There's the history that professional historians tried to create, and we're by no means objective, out of that infinity of facts. And then there's this other thing, history or memory or the stories that different people in a society tell about their past. And there are significant disjunctions within each of those. So one of the things we talked a lot about last year, particularly when we went to Washington and we visited places like Monticello, we said, how do they tell the story of Thomas Jefferson? Do they include the experience of enslaved people? They mention Sally Hemings. Right? Or when we went to Harper's Ferry, how do they tell the story about John Brown? This is a white person who tried to lead a violent insurrection to overthrow slavery. How do we tell that story? So there are struggles over how we tell the story of the past. The story of Reconstruction gets completely misshapen after the overthrow of the Reconstruction governments. And it's basically the orthodoxy which you would find in American history textbooks right up until the 1960s is essentially the story you saw in that Colfax. That this was an attempt on the part of Northern fanatics to give a group of people who didn't have the capacity for intelligent citizenship the right to vote, unleashing an orgy of privilege.